Well, welcome everyone to this important webinar. It has been compiled by the Irish Federation of University Teachers in order to explain and clarify to people employed in our sector the important issue of how to claim a contract of indefinite duration, or CID. As president of IFUT, it is my privilege to chair this event, which will be presented by two of our professional head office staff. These are Rob McNamara, who brings to us the great expertise with union organisation that he developed while working for Mandate, and Una Crowley, who, as a qualified barrister, is able to provide invaluable help to IFUT and its members whenever legal considerations come to the fore. Now, the programme for today is that Una will begin with her presentation on the Fixed Term Workers Act, and Rob will then follow on the so-called Cush Process, these being the key relevant elements that come into play in connection with obtaining CIDs. I will then chair a question and answer session with the two of them. Now, as we had requested, the questions were helpfully submitted in advance by today's audience, and this has enabled us, in order to save time and avoid duplication, to composite these down into the 8 major queries that Rob and Una will address when we get to that stage. And the whole thing shouldn't take much over half an hour, as we know that people are busy. So without further ado, let me invite Una to address us on the Fixed Term Workers Act. Thanks, Una. Over to you.
Thank you. I'll just share the screen now. The screen is up. Yes. Good afternoon, everybody. It's great to have so many of you here. Just before I launch into this whistle-stop tour of the Protection of Employees Work Act, just a few general remarks, just to outline a few things for you. Permanent contracts and employment are contracts with no end date, essentially. And fixed-term workers, they do have an end date. Fixed-term workers are engaged in contracts for a limited period of time that will expire at the end of a term, or on completion of a specified or a specific task. The workers engaged in these contracts often find themselves in very vulnerable and precarious positions because they don't know whether they're going to have a contract down the line. And this is why the legislation and the Protection of Employees Fixed Term Act is so important. Now, in saying that, I just wanted to point out, because it'll be evident as I go through this short presentation, that there is ambiguity in certain aspects of this legislation. And then it has made the treatment of Fixed Term Work Act a little bit more complex than it actually should have been. It's heavily litigated in third level and in HSE, primarily because the use of fixed term contracts are very common practice in these institutions, and it's particularly in third level, and some would argue some are needed. Of course they are. And then finally, just to say that cases brought to the WRC and the Labour Court will turn on the specific circumstances of a case. Specific grounds will be and have been dealt with in different ways by different adjudicators and in the Labour Court. But I'm going to use a few cases to compare and contrast, and you'll see what I mean when I go through the presentation. So I'll just begin. So, fixed term employment contracts are regulated in Ireland by the Protection of Employees Fixed Term Work Act 2003, which in turn transposes Council Directive 1999-70 EC. So what is the purpose of the legislation? And this is crucial, and always to keep it in mind if you're thinking about looking for a CID. The purpose is there's twin objectives of the 2003 Act. The first is to ensure fixed term workers cannot be treated in a less favourable manner than a comparable employee. And the second objective is to prevent the abuse of excessive, continuous fixed-term contracts. And this is what relates then to the contract of indefinite duration. The most significant protection given to the fixed-term employee by the Act is contained in section 9.2. It's a bit long-winded here, but I'll read it out to you anyway. It's where a fixed-term employee is employed by his or her employer on 2 or more continuous fixed-term contracts, and the date of the first contract is subsequent to the date of, with which this Act is passed. The aggregate duration of such contracts shall not exceed 4 years. So in simple terms, this means an employee cannot be continuously employed on a fixed term contract for a period of in excess of 4 years. If they are, they can then claim a contract of indefinite duration. And the strength of the provision is there where in section 9.3, where if any term in a contract, in a fixed term contract, purports to contravene section 9(1) or 2, the term will have no effect, and then it will be deemed a contract of indefinite duration. Now, this is when we're coming into the ambiguity I was referring to at the very beginning. This can only be avoided where the employer can begin or can meet the onerous test of establishing objective grounds for justifying the renewal of another contract and not giving you a CID or making the employee permanent. Now, objective justification, what is it? You'll see what I mean here now. Section 7 of the Act provides for objective justification of less favorable treatment on certain grounds for the purpose of achieving legitimate objective of the employer, and such treatment is appropriate and necessary for the purpose. And that has been interpreted in very many ways over very many years at this stage. And sometimes you would think findings contradict each other. As I said, findings turn on the very specific circumstances of a case. So significant restructuring was held to be a legitimate objective in Aer Lingus and group of workers. However, it has been held that the objective justification cannot be used to safeguard against the risk of having too many employees. It cannot be used to fill an ongoing permanent need. And the objectives that are relied on at hearing in the WRC must be the ones that the employer relied on at the renewal of the contract. Now, as I said, it's fact specific, and there are two cases that IFUT was heavily involved in 2014, and that was NUI Maynooth and Benson and NUI Maynooth and O'Keefe. On the face of them, they were both replacing permanent employees in different circumstances, and on the face of it, you would have held that both of them would have either succeeded or both of them may have failed. But interestingly, NUI Maynooth and Benson, it was held that Miss Benson was entitled to her CID, and that turned on, well, more than one fact, but on one particular fact where the Labour Court found that the heads of departments didn't actually know who Miss Benson was replacing. The person was not identified. Whereas in Maynooth and O'Keefe, she was replacing employees on sabbatical leave, and the court then accepted that it was necessary that the university continue this cover. And they found it was a desirable objective which brings benefit to both the university and teacher who avail of the leave. And this is why we in IFUT, we're always saying to people, if you think you have entitlement to a contract of indefinite duration, don't always take the first rejection from HR. Come to your local IFUT representative, and who in turn will contact head office. Again, this is just another example. I won't bore you too much with all the details. UCD against and a worker. Similarly, it was covering maternity leave, but the Labour Court held that there was no objective grounds, because the claimant didn't undertake the work that the person on maternity leave had left. She continued to do her own work that she had done previously. But by contrast, Goldara and McCarthy, the claimant failed here. And it seems odd. She was employed to cover a permanent music teacher, but that was the permanent music teacher only did 2 hours a week or 3 hours a week. And despite the fact that the school gave her extra hours, she still was not entitled to a contract of indefinite duration. So what is a contract of indefinite duration? It is all the attributes of a permanent contract. And if a CID is given or granted by the court, it should mirror the last fixed term contract and have no termination date. And that was, like, as I was saying in the beginning, permanent contracts don't have termination dates. Continuity of service is a very important one. There was a practice in the early days of the legislation for people to dismiss the employee or terminate maybe in June and re-employ again in September, October. and they had thought that was justification for not giving a CID, but actually it is not allowed. Continuity of service is not broken by dismissal followed by re-employment, and this is very important in the university sector. And the case that actually that was a Department of Foreign Affairs and a group of workers where a group of workers at the passport office had been let off every September when things died down for about 3 months and rehired again. And it was held that the continuity of service was not broken and they were entitled to their CIDs. And William Berry is another case. So at a glance, just to finish up and just to give you, as I said, a whistle-stop tour of this, is just to qualify for a contract of indefinite duration. An employee must be employed on 2 or more continuous first fixed-term contracts with his employer. The aggregate duration of such contracts should exceed 4 years. The employer must pass the objective test, and that is quite onerous. They must pass that, and strict time limits apply. And that is it, Anthony. I'll hand you back over now to Anthony.
Thank you very much, Una. I mean, that was a wonderful overview of the whole position from a legal perspective. If we didn't have you, I don't know how we would be so well informed as we are. So thank you very much indeed, Una. Yes. And you've kindly agreed to field some questions later on. But for now, we'll go straight on to Rob's presentation. And this is about what is called the Cush process, which is how we and our members engage usually with trying to enable one of our people to get a CID. So over to you, Rob, on that. Thank you.
Thanks, Anthony, and thanks, Una. Yeah, I'll just share the screen here. Yeah, hopefully you can all see that. So my presentation will cover the Cush process, the so-called Cush process, and just to give an explanation of what that is. It's far less legalistic than the process that Una was just speaking about, and sometimes the processes they get mixed up. So that's why we thought that it was important to outline the 2 separate processes that are applicable in the higher education sector. So the process is a negotiated agreement between the universities through the Irish Universities Association, or the IUA, and IFUT on the other hand. And the agreement excuse me, emanated from the expert Cush report. So that was a report by Senior Counsel Michael Cush into the precarious employment of lecturers in the university sector. It is essentially a fast-track procedure for claiming a CID. It is exclusive to union members, people can't make this a claim on their own. It is exclusive to union members, as the agreement is between IFUT on the one hand, and as I said, the IUA on the other. It is though far less onerous than a claim under the Fixed Term Workers Act. For starters, the qualification period is half of the fixed term workers. It's only 2 years to qualify for a CID under the Cush process. And we'll look at some of the criteria because this is important, as it is only expressed to apply to workers who are engaged in lecturing duties, and follows the 40-40-20 model, not prescriptively, but for people who engage in teaching, research and contribution. They must be employed on at least 1 fixed term contract. And again, this differentiates between the Act again, because the Act requires you to have 2 or more, whereas our position on Cush is that the existence of 1 fixed term contract, which is 1 fixed term contract, which is in excess of 2 years, makes you eligible to claim a CID. Like Una mentioned, in the Fixed Term Workers Act, it does not have to be continuous. So if there are periods of layoffs or short layoffs, once you have the 2 years service, you are eligible to claim a CID under Cush. Again, there are certain caveats where objective justification sort of allows an employer not to grant a CID, and they would be in limited circumstances where you were covering like a 2-year break, and that project was extended for a very, very valid reason for a short period of time, or something of that nature. Planning your application is really, really important, and I would be really careful about how you plan your application. In some circumstances, people come to us and they say that my contract, my fixed term contract has expired, but I'm still working for the institution. I have no contract, and it's been on for 3 months or 6 months, or as a case recently, 12 months. But in actual fact, you have a CID at that point. It's an implied CID, but you are actually in possession of a CID. And in that regard, you should come to us. You should speak to your branch, and you should speak to head office, because that is a really advantageous place to find yourself in, because it is then just regularizing and receiving written confirmation of your CID. So again, it's back to the planning of that application. And as I like to use the analogy, don't shoot out the traps too soon either in terms of your application. So if you're about a month away from attaining the 2-year service, which allows you to claim a CID, I wouldn't be alerting management to that fact, or the fact that a CID is imminent. I think that's something. It is vitally important that you attain the service requirement. Look, of course, you can make informal inquiries with a sympathetic head of department or that, but I would do that in limited circumstances. It is vital that you get the 2-year service under your belt. And then before making an application under Cush, I would always encourage members to consult with your branch. And sometimes it's necessary to consult with the IFUT head office for the more complicated cases. In almost all cases, we do have a look over the application forms and make sure everything is in order. But the application forms themselves are a really it's a really simple process. It is an agreed application process, so it's agreed as part of the Cush implementation pack with the IUA. It is a standard form. It captures all of the necessary information. And really, the information is only your institute, your department, a list of your contracts, starts and finish dates, and then just why we believe, the factual matrix of why we believe you're entitled to a fixed term or a contract of indefinite duration. The form is available from your branch and indeed the head office here. What happens if my application is refused? And I've used that famous graphic of the computer says no in the background there, you'll note. Because it happens all the time. Lots of applications are refused in the first instance. And as Una mentioned earlier in her presentation, it is essential that we don't take the employer's word for it. There are many myths preferred as to reasons not to issue a CID, and these must be challenged. We've heard them all. We've heard because you have breaks in the summer, you're not entitled to it. Because you're externally funded, you're not entitled to it. Because you're not called a lecturer, you're not entitled to it. These are not valid reasons for withholding a CID. So again, if in doubt, always contact your branch. But if you follow the process we're suggesting in any way, you'll have been briefed at the time you've made your application. So what's next if you are refused an application for a CID at local level? Well, at that point you contact your IFUT branch and or the head office. And IFUT at head office level will initiate a claim to the Cush adjudicator on your behalf, obviously with your agreement. And what exactly is the adjudication process under Cush? Well, it's similar to that of the WRC and the Labour Court, but a little less a little less formal. It is chaired by the former Labour Court Chairman Kevin Duffy. And I say in my opinion, he's the most, he has the most experience in considering cases under the fixed term worker legislation. Mr. Duffy was in the chair when the fixed term legislation was introduced in Ireland, and is probably, the person who decided most of the case law that Una spoke about earlier on, because he spent about 15 years in the chair of the Labour Court, making all of those precedent cases, deciding all of those precedent cases, and so he brings with him a wealth of experience, but he's also built up a lot of experience deciding these Cush cases, because he's been doing this now for a number of years. So look, what happens at that process is that IFUT would make a submission on your behalf. So we would agree the factual matrix with you. We would go through the relevant case law under Cush and under the Fixed Term Workers Act, and we would put that into submission form and submit it to Mr. Duffy. The chair then can decide that the case is solely decided on the submissions. Of course, your employer will make a counter submission, but the chair can decide that the case is decided solely on the submissions, or indeed at his discretion, an oral hearing may take place. We normally apply for an oral hearing because we believe that that is the best process to test all of the evidence, and to give your case the best airing possible. But as I said, it is at the chair's discretion. What happens after you either lodge a submission or we attend a hearing? Well, a decision will issue really quickly, which differs again from the WRC and the legislative process, because there's a lot of backlog over there in cases. It could take you 6 to 12 months to get a case through the WRC and Labour Court, where this is relatively quickly. A decision could issue around a month after the Cush adjudicator decides your case. And what did it decide? Well, in basic terms, the Cush adjudicator decides either yes, you have a case and he upholds your claim, or that you haven't and rejects your claim. But also just to say to you that there's an intervening period, and there's the period building up the case, which often gives an opportunity for the cases to be settled. And I would say half of all cases, if not more, of Cush cases are probably settled. And then I suppose the question falls, is it binding? So is the decision binding on you and the employer? It's binding on the employer. They don't have an appeal mechanism from it. So if they go through the process, they have to implement the decision of the Cush adjudicator. We, on the other hand, whilst we don't have an appeal per se, we do have you do retain the right or the option to pursue a claim under the Fixed Term Workers Act, which is the process that Una spoke about a little bit earlier. So long as you have the 4-year qualification period, you don't lose that right. So people who would come to us with 4 years or more on fixed term contracts, we would always start with Cush, because it's less formal, it's easier to progress the cases, and there's a higher likelihood of success. But then we retain the option of taking the more legalistic claim to the Cush process, which we think you can essentially gives you 2 bites of the cherry, which is a really, really positive thing for union members, and union members only, to have. And then lastly, there is a provision in the Cush agreement called the Cush hours, or we term it the Cush hours. So if you do, and you're successful in claiming a CID, well then existing staff should be offered any kind of additional hours in the universities or in your department, so long as you're suitably qualified to teach the course or do the particular role. And where those additional hours are awarded to an existing CID holder, you can actually make a further claim after a 12-month period to have those hours regularized and made part of your contract. So the idea is you claim your CID, you get the additional hours, you make a claim after 12 months, you build on those, and it increases your hours again, and nothing stops you doing that a number of times until you reach the point where you're a full FTE or 1 FTE. So we believe it's a really, really positive piece of work. Frank, the General Secretary at the time, and others done excellent work in getting this process agreed. And yeah, so we hope this presentation has been of some help to you. And as Anthony and Una both said, that there's a number of questions, and we're happy to engage and answer any of those questions that you might have.
Thank you very much, Rob. I'm sure that a lot of what you have said has already been of great encouragement to many of the people tuning in today. So yeah, that's great. Let's get into some of these questions then, which people have kindly sent in. As I say, some of them have been consolidated down, and so there are 8 of these. And the first one is for you, Una, and it was this: what rights, if any, do staff on a special purpose contract backfilling a vacant post have in connection with claiming a CID?
Well, Anthony, first of all, it's important that everybody notes that all fixed-term workers have rights under the Act. They all have a right not to be treated less favourably, and they all than a permanent employee, and they all have a right not to be placed on successive fixed-term contracts. I'm not quite sure in that question is the person is referring to backfilling a vacant post where somebody has actually left, or is it a post where somebody has gone on in an absence on a maternity leave, parental leave, or sabbatical leave, which would probably be seen as legitimate grounds. However, if it's a vacant post, definitely they have rights once it goes over if it goes over the 4 years. If the second contract goes over the 4 years in claiming a CID, an employer cannot just simply replace an employee with somebody else without establishing that the employee is actually doing the work of that's the missing staff member. But as I said, I think that with that question might be referring to just a vacant post rather than a replacement post. And in that case, absolutely, they would be entitled to apply for a CID at that stage if the second contract went over the 4-year time.
Great, thank you very much, Una. The next one is for Rob, and it's this: if I accept a permanent position in an institution, but then move to a different position within the same institution on a fixed term contract, will I lose my permanency? And this is it for someone who's been at the institution already for the necessary period of time, the 3 years.
Yeah, so up until relatively recently, the answer to that question would have been really straightforward. Yes, your substantive permanent post would be there for you when you come back. But there was recently a case, Power versus the HSE in the Supreme Court, and that question now I believe is a bit of a vexed question. So the safest option for people would be, when they're leaving a permanent post, would be to have it written into the fixed term contract that the post remains available to them to return to. And most times when people are filling fixed term contracts, you have the wind at your back, and you'll get the agreement at that stage. So my advice to that persons in those similar situations would be to seek clarification of that at the time of filling the fixed term post.
Yeah, that's important, isn't it? Thank you very much, Rob. Back to Una now, and this is in connection with something where I know, the employer often tries to make use of this. Do CIDs apply to specific purpose contracts where external funding applies, where the thing is being financed from outside?
Absolutely do, and you're right, Anthony. It is one where employers try to renege on their obligations to provide a CID. There is substantial case law now where people on external funding are not excluded from the application process, or indeed for getting the CID. Again, as I said in the beginning, there are ambiguities of the legislation, and cases do turn on the specific facts of the case and the circumstances of the case. So it is very difficult to give a blanket yes or no answer on that one. But if people were interested in looking at, there's a good case there, UCD and O'Riordan 2011, and this is an interesting one where the claimant was employed under a series of fixed-term contracts, writing up a series of textbooks in Irish history. Now that project was externally funded, but the claimant still succeeded in his claim because the Labour Court held there was no objective grounds for justifying the claimant not, because he was not doing the work normally expected of a postgraduate researcher, which is what the employer was claiming. Unfortunately, there is a turn on this, and this is what people know. Even though he was given or granted a CID, entitled he could have a CID, the Labour Court didn't reinstate him. Instead, they compensated him because there was a fear that the university would have made him redundant after a certain period. So that's what I'm saying. It's not so straightforward, and it's very difficult to give a very straightforward answer. It really does depend on the circumstances, and but what I will, in a brief answer to the case, absolutely, if you are on external funding, you are not excluded from the process, and that's absolutely true, and there is substantial case law that will back that.
Thank you, Una. So on the whole, that's encouraging news, isn't it?
It is. It's very, and I wouldn't discourage people, but what I'm saying is that, as I said at the very beginning, it is important to note under the Act, it really does. I mean, there would be case law that people could look up then where a researcher wasn't given it, but look, it is certainly, they are not excluded from applying it. It's very positive.
Thanks very much. The next one's back to Rob, and this will be relevant to a good many people in our world, in the higher education world, where people have postdocs and fellowships, many of which, can be designed to last for 2 years or 3 years or 5 years or even 7 years. And the question is this: are occasional lectures or staff on fellowship or postdoc research contracts, are they entitled to a CID?
Again, similar to what Una said earlier on, there is no blanket reason why people on those contracts shouldn't be entitled to a CID, and we have many examples of people actually successfully claiming a CID under both Cush and the Fixed Term Workers Act. So there is an example of that. There's a perfect example of a case in point where you should seek advice from your branch and from the head office, because we would have a large expertise around sort of directing that person in the right direction. But in short, yes, I would say nothing excludes those people from claiming a CID once they meet all of the other criteria, whether it's the 2 years under Cush, whether it's the 3 years under the Fixed Term Workers Act. Yes,
that will become as news, and potentially very encouraging news to a number of people, I think. Thank you. Now back to Una, and this feeds, I think, probably on from the previous answer you gave. Can a staff member who is currently on a CID be made redundant if they're funded from a time-limited project rather than from core institutional funding?
The answer here is yes, but it's saying yes. Any post can be made redundant. It is highly unlikely, and it is a rare case in public service where someone would be made redundant from a post. There's loads of different obligations. Redundancies Act there's lots of obligations that come with making someone redundant. It's the post that's made redundant, not the person. And there is an obligation for the employer to find suitable alternative, or to offer suitable alternative employment. If you're a researcher, are there other research? If you're a lecturer, so it is very difficult to make anyone redundant on a CID. I'm not saying it's impossible, but certainly it is very difficult.
Thank you very much. And from IFUT's history, we have saved not just individual but whole cohorts from redundancy when institutions have been closed down. We've managed to get them transferred and so on. So yeah, that's another piece of encouragement. Thank you. Now, Rob, one for you. Someone says, I'd be interested in hearing examples of where researchers have successfully argued for a CID, even though they have been on fixed-term specific purpose contracts.
Yeah, I mean, look, it probably circles back to the earlier questions. We have had examples of it, and a number of them in the last 12 months. Well, I'm not going to go into the details of them obviously for privacy reasons, because some of the cases were settled and others went the distance to adjudication. But yeah, I mean, we've had roles in DCU, fellowship roles in DCU. We've had researchers in Tyndall in Cork just in the last number of days who we assisted with making application, and they were granted CID. They were on specified purpose research projects tied to funding. And then we're on a number of different sort of funding agencies over their time. I think that the gentleman had 6 years in total on different projects, different funding streams, and yeah, and we've had success in those. And people will be aware of the case in Dias, which made the national media in the last number of months, whereby a researcher postdoc researcher claimed a CID through IFUT, and that went all of the ways to the WRC, and we were successful. And they didn't accept the line of argument that because the role was coming from different funding streams, that he wasn't entitled to a CID, or the person in question wasn't entitled to a CID. So absolutely, we have those examples. And again, I'd say come to us, discuss it before making any claim under any piece of legislation, or indeed the Cush process. So yeah, we have had those successes.
Good to hear. Thank you, Rob. And Una, this is to do with the accumulated time that you have to clock up. The question is, to be eligible for a CID, do all the previous contracts need to be 100% time, in other words, full-time equivalent? Or is the unbroken service the more important factor? So in other words, is it the number of years, albeit part-time, or is it the sort of total number of hours? Which of those is the thing that counts?
Well, they both count, the answer. Previous contracts do not need to be 100%, no. But you do need to have 2 or more contracts, and fixed term contracts, and the aggregate duration needs to exceed 4 years. Okay. Continuity, continuous service is extremely important. But as I said earlier, when we were talking about Department of Foreign Affairs and that case around the passports, continuity service is not broken by being laid off and then 3 months later being re-employed. So there is, you could have like all of the summer period in a university. If you finished in term time in June and you were rehired in September, that would not be considered broken. But continuity service is important. But as I said, it isn't broken by short-term layoffs. So the answer to the question, yeah, you don't need 100%. Your contract in the end, if it's the aggregate is 4 years, your CID will mirror the last contract and the conditions of the last contract.
I think that's the important point in that question. If I may just jump in for a second, because I think the person feeling the question or asking the question may be confusing a CID with a full-time contract. So as Una said there, it is the last contract. It does, because you get a CID doesn't mean you get full-time hours. It merely, sorry, not merely, but it mirrors the last contract that you had when you claimed the CID.
Yeah, thank you. Yes, that clarifies things. Thank you both. And then the final one is to Rob, and it's a sort of simple question in a way. I'm unsure how CIDs are communicated to eligible staff. I presume that means, how do people know what the process is in their own institution? I presume that's what the question is.
I would say institutions work really, really hard so that you don't know you're entitled to a CID, and I don't mean to be in any way flippant about that. They will not advise you as to your entitlements to a CID, and that's what we're here for. And on that basis, I would encourage anyone to reach out to their branch, reach out to the head office, and if you're not a member, to join, because there is nobody else out there that is going to assist you or bring to your attention your entitlements and your rights to claim CIDs under both pieces that we were speaking about today.
Great. Well, thank you both very much indeed. I'm sure I'm speaking for all of us in thanking Una and Rob for a most illuminating and helpful event on this very important topic of CIDs. Those who are members of IFUT will already know what great service we get from our head office staff. Una and Rob are just 2 of our 5 professionals there, and they all help us with specific cases as well as on general matters that range across the union, as in today's session. To viewers who are not yet members, please go to the website www.ifut.ie to arrange about joining. You see the kind of rights and services you have been missing and will go on missing unless you do. And finally, just to let everyone know, a podcast version of today's event will be available on IFUT's social media channels shortly. So in the meantime, many thanks again to our 2 speakers and to all of you, our viewers, for joining us today. Thank you.
Thank you. Thank you very much.